Hi, everyone. This is Alex Reby, and I have Ben Asario with me here today. We are two of the partners at Murray Asario. And what we're talking about today is what happens when you lose in the unfortunate situation that you lose your case with the immigration judge. What options you have, what can happen to you. So I'm going to have Ben here answer a couple questions about that. So Ben, first of all, you lose the unfortunate reality that sometimes your case is denied. So you lose your case. Is ICE going to come snatch you, handcuff you, and deport you that evening?
No, in a non-detained setting.
Right. But even in a detained setting,
your case is not over yet. So typically, in both a non-detained and a detained setting, you have 30 days to file the notice of appeal. So during that time, there is an automatic stay in place. So I have never seen a situation in my life where a non-detained person loses their case and then ICE shows up to detain them. That's not a thing that happens.
Right. So you lose your case. I've heard of people who have decent cases not even showing up to court because they're worried that if they lose, ICE is standing outside the door with handcuffs and they're going to detain them. And that does not happen. Never seen it happen. It's not likely in the least. Okay, so then you just mentioned that you have 30 days to file an appeal. What if you're still thinking about it, and then you realize that 60 days have gone by? What do you do then?
I would say that situation depends on if you had an attorney or not. If your attorney failed to advise you that you had 30 days to appeal, you may have a malpractice claim that you could then remedy through a motion to reopen. If you were advised of the 30 days, you chose not to file the appeal during that time period for whatever reason, you may have waived your right to an appeal.
So that's important. So the 30 days, it's not, okay, I'm going to think about it for a while. And if I get, there's a lot been going on the last 30 days. My child had a school play. I didn't have a chance to think this through. Yeah. It's not going to be it.
It's not a good thing. I would be hesitant to tell people to even wait to the 30th day. There are very few circumstances that I would recommend that. So given that the BIA still has to kind of process it into the system and accept the appeal, I would recommend filing no later than the 28th day, because I just get uncomfortable sometimes if they could reject something for failure to file a fee. I just want to have at least enough cushion there to maybe give myself a second bite of the apple before the actual deadline.
Right, like you missing a signature, they reject it, they'll let you know that same day. Okay, well, I still have a couple days to remedy this if it's something silly like that.
Right.
Okay, and you mentioned the BIA. Who's the BIA?
The BIA is sort of the immigration appellate level. It's comprised of a number of different board members. That number can change. There can be temporary board members, but those would be the individuals deciding your appeal. The appeal will be all writing. Typically, there's not oral argument, so there's very few times on a BIA appeal that you will ever have any in-person interaction with the board. But it could be one person adjudicating your case, or it could be three people. There's a different sort of process depending on what the issue in your appeal is. So that is how the BIA at that level operates.
So let's say you were my attorney and you represented me in the asylum case, and unfortunately we lost the case. Are you going to need more evidence from me to do the BIA appeal?
So the typically in almost all appeals, both criminal, civil, immigration, whatever type of court you may be in, usually you're bound by the trial level record. So it's very hard to submit new evidence. Not impossible. There are certain situations. Let's say that you had failed to disclose a sexual assault, because those things are very difficult to talk about, to your attorney prior to the individual hearing. And for whatever reason, stuff came out that may have affected your credibility regarding that. If you went and got therapy or were seeking counseling or on medication, or even if a new event happened that may affect your eligibility for asylum, let's say that another family member was attacked in the home country, then there may be an opportunity to present new evidence at the board, but those are very rare circumstances. Usually if you're just arguing the judge made the wrong decision on this, usually you're bound by the evidence that was submitted on that topic before.
Do you have to use your same attorney? Let's say you hired an attorney, you really didn't think that they prepared you well, you don't think that they filed the evidence timely, you're really not very impressed with them, and then you lose your case. Do you have to use them again?
You do not have to use your same attorney. I mean, there's two sides to this. There are really good attorneys that have lost cases in front of immigration judges. That's just the facts. There are tough immigration judges. There are easier immigration judges. There are all types of circumstances.
Yeah.
There are difficult cases to win. There are difficult country conditions that may have changed since you left that country. So your attorney could be really good and have lost the case. That being said, there's not fantastic immigration attorneys out there as well, and you can always change your immigration attorney. There is some benefit, I would say, if you trust your attorney, have a good relationship with your attorney, and think that they're doing a good job, for them to continue on with the appeal, just because of their already familiarity with the case, having litigated, their familiarity with the record and the judge, and the decision in that case. But you are more than welcome to change your.
But let's say I want to hire you to do my appeal because I wasn't happy with my attorney. How are you going to know what happened, what I said at the court hearing?
So when you file the notice of appeal in that 30-day window, there's a long time, typically even on detained cases, before you get the transcript. And so you will receive a transcript and a briefing schedule. The briefing schedule is typically due 21 days after you receive it. You can usually ask for another 21-day extension on top of that to submit your briefs. But that transcript will have everything in the record. Typically, we also submit an EOIR FOIA if you were to retain us for your appeal. So we will get the actual record evidence that was submitted as well, in case your attorney doesn't have it and we didn't get it in a file release. So there's two sort of ways that we will have everything that was both said and filed in your case.
So so be clear, everything's recorded. So just because that attorney wasn't there, didn't help you litigate the case in the first instance, they'll know exactly what it is that was said. And then how, if you're non-detained, you're not in a detained, and when we say detained, we mean in an immigration detention facility. Let's say you're non-detained and you've lost your case. When can you expect a decision on the case?
I think that's very hard to say. So recently, DOJ released sort of their end of year for 2023 numbers of cases that have been processed and cases that were pending at the BIA. Right now, and this is not a fixed timeline, I would say cases are taking 3 or 4 years for them to issue a decision. Now, that being said, cases that are electronic, we've seen them issue faster briefing schedules. We've not seen faster decisions yet, but I think it's hard to say yet how the ECAS cases are going to be treated.
And am I going to have a new hearing? Am I going to have to testify again?
You will not have a new hearing unless you succeed on your BIA appeal, and then it is remanded back to the immigration judge, which may determine whether you have to take more evidence, more testimony, or not. So at the BIA, you will not take more testimony.
Okay. And do I need an attorney to file a BIA appeal?
You do not have to have an attorney, but this is very complicated. I recommend to all of my family members to go seek a competent lawyer on anything but a traffic ticket. My family members come to me on divorce questions, on family law questions, on tax questions that I am not qualified to discuss because I'm an immigration attorney, and I advise them to seek an attorney in that area. Again, you could do this pro se by yourself. I would strongly, strongly encourage you not. Appeals are very complicated, and if you have lost, it is, it's very hard to overcome given the standards of review. Even if you've won and DHS files an appeal, I would still encourage you to seek legal counsel because you want to defend the grants from the immigration judge of that appeal. I want legal help, legal qualified help to do that.
And then the tricky question that we hate answering, but people always ask, what are your chances of winning an appeal?
I have no idea. I mean, it's going to depend on the specific issues in your case. It's going to depend on whether there's been a change in case law. It's going to depend on the specific country that you're from, the country conditions, the reasons that your case was denied, the reasons that you were applying for asylum, the reasons that you needed a waiver. So all of that stuff is very case specific. And even beyond that, you have no control over the adjudicators who are assigned to your case, and they're human beings too. So it's just very hard to say without having reviewed your specific case, your specific evidence, and your legal arguments.
Yeah, and because different reasons for denial have a different standard of review. Like, was the judge wrong on a fact that he stated in his conclusion? Was he wrong on an area of the law? Like they all have different standards of review, meaning how does the BIA judges look at that decision? How much deference, how do they give that judge for their decision? So difficult question, but it's not impossible to bounce back from a loss. You obviously don't ever want to encounter it, but seeking a good immigration attorney or staying with your attorney if you were happy with that attorney, absolutely do that as soon as possible after losing so that you don't have a situation where you wish you would have appealed, but you just ran out of time and didn't think that there was any hope left. So definitely talk to your attorney or seek a second opinion, right?
Yeah, I mean, one thing about that too, though, is people's life circumstances change. You may be eligible for some new relief, even if you've waived appeal.
Yeah.
And let's say you lost your immigration court case 3 years ago, but you're now married to a U.S. citizen, and that wasn't presented at the time. You may have new options for relief, or you may have an ability to adjust through them and need to consular process and need to go back and reopen your case. So should you file an appeal, should you seek legal counsel to discuss whether an appeal is viable in your case, I would strongly recommend that you do so. But, again, you may have new options that might also merit you having a consult with an immigration attorney too. So, I mean, the door doesn't necessarily have to always be closed forever. But yes, I would strongly encourage you, if you lose a case, file an appeal.
Yeah. Okay, well, thank you for those answers. And thank you, everyone, for your time. And contact us at Maria Sario if we can help you with any of your appeal questions. Bye-bye.